Hi, in this lecture I'm going to talk you through how I think you should answer question 1 from the October 2018 Intellectual Property exam. As there's no published examiner's report, we've got no way of telling what the examiner thought, but I don't think my ideas are going to be very different. The question, as often happens, is in the form of an unattributed, and I think almost certainly invented, quote. Would any reasonable person actually hold this view? I guess it's no surprise that the examiner asks you to talk about a rather extreme viewpoint. So being as how it's an essay question, it's short and to the point. It tells you that in the opinion of the author of the quote, IP rights do not reward creation. Instead, they merely concentrate market power, and therefore they should be abolished. The examiner's instruction to you is to discuss this proposition. The question doesn't say discuss it critically, but I think you should take that as read. I think your approach should be to take each of those parts of the proposition in turn. First of all, the statement that IP rights do not reward creation. Is this a fair comment about all types of IP rights? Because IP covers a wide range of different unrelated rights, so to my mind this is a sweeping generalization. The reward and incentivization analysis works quite well with copyright and with patents, to a lesser extent perhaps with designs, but not at all with trademarks, which are not concerned with creation at all. They're concerned with the protection of business goodwill. Nor does the incentivization analysis work with breach of confidence. Okay, strictly speaking, that's not really an intellectual property right at all, but the law on breach of confidence protects information, not because it's novel or original, not in order to reward the creator, but simply because it is confidential, and it would be inequitable to allow others to use the information. So as with any question in an exam that asks you about intellectual property as a whole, it's well worth starting off by stressing the variety in the intellectual property field, and the fact that a statement may be true of some types of intellectual property, but not of others. The examiner often asks about justifications for intellectual property, which I don't think is what he or she is getting at here. But there's certainly room in this question to write a little bit about justifications. And what I suggest you do here is to dig down into your knowledge of the justifications for IP protection and pull out the parts that relate to the importance of encouraging creation. You might talk about Locke's labour theory of property, and how you have a sort of natural right to what you create. But I think more to the point, you can talk about the utilitarian approach and how the greatest good is obtained for the greatest number by giving creative people and inventors exclusive rights, which may in themselves have harmful effects, but which deliver benefits to society at large which far outweigh whatever drawbacks they might have. At this point, if I was answering the question, I would tell the examiner about Dranez Anstalt against Hayek, a 2002 Court of Appeal case in which Lord Justice Chadwick took the trouble to explain to us why patents are justified. The justification for patents works pretty well for copyright as well, although we might have to look elsewhere to justify trademark protection. I don't expect you'll be able to memorize this quote from the Hayek case and trot it out in an exam, and I think that would be a waste of your brain power if you used it for that purpose. Also a waste of writing time in the exam. But what strikes me about this quote is that Lord Justice Chadwick is justifying patents in terms that could come straight out of the writings of Jeremy Bentham. It's an entirely utilitarian analysis. The system encourages inventors by conferring a monopoly on them. The public suffers a disadvantage because of the existence of the monopoly. While the patent remains in force, there's only one person they can buy whatever it is from. But on the other hand, if the inventor hadn't been encouraged to make the invention in the first place, the product wouldn't have been on the market at all. So its presence on the market, its availability, is a benefit to the public. And so long as that outweighs the disadvantage of being tied to a single supplier for the duration of the patent protection, 20 years, a member of the utilitarian school of thought will say that's a good thing. For the purpose of the rest of the exam question, the third sentence of this quote is quite telling, but the balance between the benefits which will accrue to the public from permitting monopolies in order to encourage invention, and the detriment which may be suffered by the public from monopolistic practices is struck by the patent legislation. All intellectual property legislation is concerned with striking this balance. The law grants exclusive rights, but tries to ensure that they go no further than is necessary in order to secure a benefit for the public. And I think that proposition leads us neatly into the next part of the answer. The second sentence of the question asserts that intellectual property rights serve to concentrate market power within companies. I'm not going to waste time on those words "within companies" at the end. I think they're a bit ambiguous, and if you're going to be pedantic about it, I don't think it matters whether market power is concentrated within companies or in the hands of individuals or in partnerships or in any other sort of legal or natural person. The point is that granting any sort of exclusive rights inevitably confers market power on the person who has those rights. If somebody has the exclusive right to extract coal from a particular piece of land, they've got some market power. It's not a lot of market power if the person next door can dig coal out of their land as well. If you own the town's only diamond mine, that's a different matter. That might give you a bit more market power. Ownership of a patent certainly puts you in a strong position. It confers a monopoly, but for starters, it's only a monopoly over what's claimed in the patent. Ownership of copyright gives you control over the exploitation of the copyright work, but it doesn't stop other people creating similar or even identical works. So a second inventor can always create a better invention, and a second author can always create another copyright work which may even be identical to yours. And no form of intellectual property is absolute. There are exceptions, exclusions, permitted acts built into the legislation that deals with every type of intellectual property, and which operate as a kind of safety valve to prevent the intellectual property rights getting too powerful. And of course intellectual property is limited in time and also in geographical extent, although the geographical limitations can be overcome by obtaining patents in foreign countries, for example, and in the copyright world, because the Berne Convention ensures that authors get automatic protection in all the countries that are parties to it. So yes, intellectual property does concentrate market power, and it concentrates market power, initially at any rate, in the hands of the creators and inventors. This balancing act is very well shown by reference to design right, Part 3 of the Copyright Designs and Patents Act 1988. It strikes a very careful balance between the incentivization effect of granting intellectual property protection and the detrimental effect this has on competition, and therefore, quite clearly in this case, on consumers. So if I were writing the answer to this question, I'd probably use this as an illustration, but a lot of that has got to do with my personal preferences and the fact that I did a lot of work in this area at the time. The whole idea of the way that design right was put together is to ensure that car makers who own the designs can't control spare parts, and that other companies have got to have the ability to make competing spare parts in order to allow market forces to drive the prices down and for consumers to get a good deal. And in the design right legislation we've got the must fit and must match exclusions, which ensure that independent parts manufacturers won't infringe when they copy certain aspects of the design of a component. We've got a very limited term of protection, generally speaking 10 years from when articles are first placed on the market. We've got licensing of right provisions which kick in the last 5 years, so that again independent manufacturers have got the ability to get into the market, although they've got to pay a royalty during that 5-year period. And as part of the same general scheme of things, we've got the exclusion of copyright protection under Section 51 of the Copyright Designs and Patents Act, which incidentally the examiner loves, and until it was repealed, Section 52. But Section 52 is another story altogether. So my argument would be, by reference to this illustration, that intellectual property law doesn't concentrate market power because it's specifically designed to ensure that this doesn't happen. The areas where protection could overreach and give the owner more rights than are justified is all taken care of in the legislation by means of exceptions, exclusions, and so on. You could make a very similar argument by referring to computer software and the exclusions or permitted acts in the copyright legislation. You could make similar arguments by referring to what the patents legislation allows people to do without infringing, and also what's allowed under the trademarks legislation. My design right example, and I think other examples as well, all amount to a recognition that competition law isn't agile enough to deal with all abuses. And I think this question requires some discussion of competition law in order to complete the argument. So, intellectual property rights confer market power. The law is carefully designed to try to ensure that that market power is minimised so that competition isn't adversely affected. I think there's a further element that needs to be taken into account here, which is the concentration of intellectual property rights, in the sense that businesses can accumulate extensive portfolios of intellectual property rights, and not just rights that they've created or their employees have created in-house. Record companies and film studios collect copyright, often using options and exclusive contracts that restrain trade, which are particularly common in the music industry. And you might come across one or two cases from many years ago now which concerned whether the restrictions contained in a record company's contract were in unreasonable restraint of trade, tying the musician to the record company for an unreasonably long period of time. Film studios commonly pay a lot of money to secure an option over the right to make a film from a book. It may be quite a long time before they get around to doing anything with it. But in a sense, all these rights are their stock in trade. Technology companies, particularly in recent years, have devoted a lot of time and energy and money to collecting patents. Not necessarily because they want to exploit them, but very often to enable them to be in a position to offer cross-licenses if and when they infringe somebody else's patent. There have been many cases, most of them I think in the United States, involving Apple and Samsung in particular. It's very hard in a crowded area of technology where there are many patents to do something which doesn't infringe, or at least which doesn't look as if it might be infringing, and therefore encourage the patent owner to have a go at you. And what technology companies are quite anxious to do is to put themselves in a position where they can say, well, we might be infringing your patent, but we've got one here that you're infringing. So we'll take a license to use yours, you can have a license to use ours, and we'll get on and make some mobile phones now. Of course, none of that fits within your normal justification of the patent system, but it's a fact of life that that's what's happening. And I think it's an important illustration of the way in which intellectual property rights are concentrated in particular businesses. There's a phenomenon known as trolling in the patents field, where patent trolls collect unused patents and then set about enforcing them. They look for people who might be infringing and they sue them. They don't use the patents themselves, they don't have the expertise or the facilities to use the patents, they simply collect them and sue on them. Again, not something that's covered by the normal justifications for the patent system, but a fact of life. and something that businesses in all areas of technology and so on have got to learn to live with. In the trademarks field, we haven't said very much about trademarks so far in this answer. There's a concentration of intellectual property rights because trademark owners register extensive rights. They try to make their trademark portfolios as strong as possible, and they do that by registering not just for the core goods and services that they're actually interested in, but also for all kinds of peripheral things. And these days they're not so peripheral, really. I dealt with an opposition a while ago where I'd applied to register a trademark for a television business, and they were opposed by a high street clothing business. But the clothing company's trademark registrations extended to television programs and so on, and I have no doubt that in the modern world they are engaged in producing television programs. It's not quite a case of everybody doing a little bit of everything, but certainly businesses do all kinds of things outside their core activities these days. You might criticise the ease with which trademark owners can collect together extensive rights like that, and you might say that this has a severe effect on competition, a severe effect on freedom of commercial speech. When a television broadcaster can't use its trademarks or can't register trademarks for its program names because they conflict with something that a clothing retailer is doing, that shouldn't be a problem in the trademark system. But the neat way in which the trademark system tries to compartmentalise goods and services breaks down as the world changes. So many years ago, the Beatles record company were able to reach an agreement with an emerging computer business and say, we'll use the word Apple in the music industry, you can have it for computers, and surely there's not going to be a problem. And the rest is history. So there's a few examples of how intellectual property rights become concentrated in terms of ownership and I suppose extent. It's important to note that none of this is inherent in intellectual property in itself. It's a situation that arises because of transfers or because of rules about ownership. So record companies and film studios are collecting copyright from creative people. They don't create it themselves, they acquire it. The fact that it happens isn't an argument for abolition. The fact that Apple is collecting patents as fast as it can so it can defend itself against Samsung isn't something that's inherently wrong with the intellectual property system. It's not an argument for abolition. It might be an argument for some other sort of intervention, but it doesn't mean to say that the intellectual property system fundamentally isn't doing its job. And the fact that trademark owners register such extensive rights that they turn their limited exclusive rights into absolute monopolies doesn't mean to say that the trademark system should be abolished. It might be even broken and require some sort of change, but doing away with it isn't the answer. The simple fact is that intellectual property is a business resource, and you've got to expect that companies will do what they can to accumulate the means of production. So that brings us to the third point in this question, the suggestion that intellectual property rights should be abolished. As a starting point, I think I'd observe that few people suggest abolishing property rights in other business assets. It would be absurd to say that ownership of a factory puts you in such a strong position that you shouldn't be allowed to have any property rights in it. Karl Marx might have advocated a different approach to the ownership of the means of production, but that was rather more than simply abolishing what was already there and doing away with the property rights. What's needed in order to deal with the problems that are mentioned in the examination question is to draw a distinction between the existence of intellectual property and the exercise of intellectual property rights. And this was a process that the Court of Justice had to go through in the very early days of the European Economic Community, back in the, probably not the late 50s, but throughout the 60s and 70s. That's the 1960s and 70s for those of you whose memories don't go back as far as mine does. The issues which are identified in the question are to do with the exercise of intellectual property rights, not with their existence. They need to carry on existing in order to provide the incentive for people to create and invent, and I suppose you should say in the trademarks field to carry on devising trademarks which will serve to distinguish their goods and services from those of other undertakings, and therefore enable consumers to identify very easily and very efficiently which goods and services they wish to buy. That's the utilitarian justification for trademark protection, not because it encourages creativity, but that it encourages the creation of something which is very useful to consumers, and indeed protects them from the possibility that two businesses will be selling goods that cannot be distinguished, so the consumer ends up buying the one they didn't want. So intellectual property rights should not be abolished. They should perhaps be circumscribed very carefully, and where problems do arise, they should be dealt with by competition laws, specific legal mechanisms to deal with excessive market power. Article 102 of the Treaty on the Functioning of the European Union and Chapter 2 of the Competition Act 1998 in the UK deals with abuse of dominant position, and the McGill case from 1995 tells us exactly how this applies in the field of intellectual property rights. McGill was a publisher who wished to produce a weekly television listings magazine covering Ireland and incorporating information about the programmes broadcast by the BBC, ITV and RTE, because they could all be received in Ireland. People didn't want to have to buy 3 separate listings magazines, which is what we used to have to do in the bad old days. But not surprisingly, the publishers of those listings magazines sued them for infringement of copyright, claiming that they owned the copyright in the listings themselves. And that was eventually held by the Court of Justice to be an abuse of the dominant position that the publishers were in. They were in a dominant position, not automatically because they owned the copyright, but certainly it puts them in a very strong market position, and they abused that dominant position because they used their copyright not just to stop straight competition, which would be fine, but to prevent the emergence of a product that consumers wanted but it didn't suit them to make. That was what was abusive about that exercise of the copyright, and that's why the distinction between exercise and existence is so very important. Article 101 of the treaty in Chapter 1 of the 1998 Act also prohibits certain restrictive agreements, and this is particularly important in the intellectual property field because it covers exclusive licenses, exclusive patent licenses, exclusive know-how licenses, to a lesser extent exclusive copyright and trademark licenses. Going into it in more detail is beyond the scope of this answer, I think, but the important thing is that there is a legal mechanism there to control the exercise of intellectual property rights in the field of exclusive licensing. And finally, I'll mention the doctrine of unreasonable restraint of trade, which I already touched on earlier. A contract can be in restraint of trade. That in itself isn't a problem, but if the restraint is unreasonable, then it is a problem, and at common law that contract won't be enforceable. And it's a doctrine which has been used as a way of controlling the problem that this question identifies, challenging the exclusive contracts that were imposed on young musicians by record companies, and it could apply elsewhere as well. So far from abolishing intellectual property rights, I would suggest that what we need to do is to look carefully at the exercise of intellectual property rights and look at existing mechanisms, and perhaps mechanisms which don't yet exist but which are desirable, in order to control the exercise of the intellectual property right rather than talk about abolishing them. Sometimes these problems can be dealt with by shaving bits off the intellectual property protection, which is effectively what design right does. It tells you that designs are protected, and then it says but not must fit, not must match, and so on. But that's really cutting back the intellectual property right in order to deal with competition problems. And you can deal with those problems without making intellectual property rights so weak that they offer no incentive to creators and inventors, because the danger is if you attack or reduce or even abolish intellectual property rights, you throwing the baby out with the bathwater. So if you've allowed yourself enough time, you can now write a little conclusion. I think you can conclude from what you've written, well, unless you completely disagree with me and you've written something different, that intellectual property rights are not inherently anti-competitive. In fact, they're designed to be pro-competitive. They're pro-competitive because they encourage the flow of new products and services onto the market. If they were abolished, what incentive would creative people and inventors have? You'd have to devise something completely different. You'd have to have systems of prizes and patronage like they used to have back before intellectual property rights were really invented. So you would have composers employed by, well, not royal courts these days, probably by hedge fund managers and other people with lots of money to indulge themselves. You would have bodies like the Royal Society of Arts awarding prizes for inventions, which they still do on a small scale, but nothing like as important as the patent system. Creative people and inventors might do their work just for glory, either for personal glory or perhaps in some political systems for the glory of the country or the regime or the people. I don't think either of those will be as reliable as the intellectual property system that we've got. The correct approach to the problems identified in the question is surely to control the excesses. Abolition is too blunt an instrument. Well, I think that's turned out to be more a lecture about what material should go into an answer to that particular exam question, instead of a lecture on how to go about answering it. They're not quite the same thing, but I hope that what I've said is going to be of use to you anyway in working out how to go about dealing with a question like that. I hope you found it useful, and I hope you'll find some of my other recorded lectures useful as well.